So good afternoon. A lot of what was said then I thought I was going to need to say, so there's not a lot more other than to welcome you all to King & Wood Mallesons this afternoon. As Anne said, the firm has had a very long association with the University of New South Wales and the UNSW Law Journal. Having you here, we're delighted to have you here, just as a sign that we're continuing to support and associate with both the university and the journal. A lot of work obviously goes into preparing these journals, and it's an exceptional commitment that people make, and it's something that Shavika has done. The next step for this evening is really to invite her up to talk to you. So if I could welcome Shavika. Could you all welcome Shavika?
Thanks so much, Michael. Good evening, Justice Pepper, Professor Williams, and distinguished guests. I too would like to begin by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of this unceded land, which we now call Sydney, and on which we meet tonight. I pay my respects to the Gadigal elders past, present, and emerging, and I acknowledge their continuing culture and the contribution they make to the life of this city and this region. Thank you all so much for coming tonight to the launch of Issue 4, Volume 42. It's so wonderful to see so many familiar faces in the crowd, from those who encouraged me to join the journal more than 3 years ago to some of the authors I was so lucky to meet just a few moments ago. I'm very grateful for the effort I know many of you have taken to be here tonight, especially on such a hot spring eve. Before I get into discussing the contents of the issue, please indulge me in a few thank yous for the numerous forces of nature who've contributed to raising this issue, to the carefully constructed publication that you see bound before you, eager to be picked up and devoured by your curious minds. Foremost, my thanks must go to the 25 authors of the 11 articles within this issue. You have each contributed an outstanding piece of legal scholarship that will advance critical discourse in your respective fields. Thank you for letting our editorial team co-parent your articles for the past many months, and for your continued patience throughout the process. It's been a real pleasure to work with you, even though it's been largely through email. I also thank the many anonymous peer reviewers for offering their expertise. Their eager willingness to volunteer precious time and provide detailed referee reports speaks to the remarkable generosity characteristic of the Legal Academy. As a student-run publication, these reports greatly assist the executive in coming to its decisions and provides invaluable commentary on which the authors also rely to revise their articles. I'd also like to thank King & Wood Mallesons for their generosity in hosting the launch event today. It's a pretty bold statement, but after some rigorous, extensive empirical research, having attended numerous of these events, I think you have my vote for the most jaw-dropping view out of all the law firms. No doubt this view will be trending on the Instagram stories of many budding UNSW law students tonight. Jokes aside, without the ongoing support of our premier sponsors, we would not be able to sustain the journal in its current form. We're also very fortunate to enjoy similar support from our other premier sponsors, Herbert Smith Freehills and Allens. To our faculty advisors, Rosalind Dixon and Gary Edmond, who unfortunately couldn't join us tonight, I thank them for their trust in our capacity as a student-run endeavour and unwavering investment in this publication. I'm particularly grateful for their patience in guiding us through the bumps along the road and for helping shape our sometimes half-baked ideas and giving them some sort of discernible form. I also extend my gratitude to our Dean, Professor George Williams, and the UNSW Law faculty for their ongoing support. Now, most of you don't know this, but the journal's editorial board is in fact an elaborate front for the secretive Pedants Anonymous, comprised of a pedigree of law student who will obsessively correct your grammar without you asking for it, and who cannot sit still if they recognise an italicised space. They revel in the agonies of citation. Pedants Anonymous is, however, not so anonymous at all. You'll find their names listed on the first page of the journal. Please read these names carefully. They're some of the best and the brightest of our law school, and I have no doubt they'll go on to achieve wonderful things, sweeping all future documents clear of editorial horrors. Thank you to each of you for your wonderful humour, diligence and commitment. My most heartfelt thanks goes to the current and former members of the Executive Committee. Thank you guys for your boundless encouragement and for offering a helping hand at really crucial times throughout this past year or so. Actually, it's been 15 months. These 15 months have been made endlessly enjoyable as we've debated everything big and small. So I'd just like to say for the record that Monday is the first day of the week. I think this gives everyone in the room a bit of idea of the wild conversations and debates that go in the journal office. It's been my privilege to work alongside you, learn from you, call you my friends, and thanks a lot. Special thanks also goes to Executive Editor Anne Young for her stalwart leadership and really rising to the role over this past year. It's been really great that we've gone to work together. And as Anne mentioned, I'd like to give a special thanks to Antonia Zhu, Digital Editor, and Aisling Brelton, Forum Editor. Their work goes on largely behind the scenes and online, so they don't really get the opportunity to stand before you all at these launch events and receive the praise they so sincerely deserve. Aisling has overseen and guided not only an impressive growth in the number of submissions we've received to the forum this year, but also contributed to raising its profile as a leading companion to the journal. Last but never least, thank you to my family and friends for your support, patience, and distractions as my time of issue editor. I'm so lucky to be surrounded by people who challenge me, forgive me, and poke merciless fun at me. Yes, keep my ego in check. Another thing that you might not know is that this marks the 45th year of publication. For 45 years, the journal has been publishing original, high-quality, and thought-provoking scholarship. Unsurprisingly, the 11 articles which comprise this issue continue this trend with an outstanding diversity of topics. We have first Evgenia Barova, Ian Ramsey, and Paul Ali examining the limitations of consumer credit law for female victims of economic abuse. Then Jacob Flynn, Rebecca Giblin, and Francois Petitjean undertake an empirical analysis of copyright law's underuse hypothesis, which is done by investigating the availability of ebooks across public libraries. Kathleen Daly and Juliet Davis chart the development of the National Redress Scheme for Institutional Abuse, Child Abuse, which is following the Royal Commission. Harry Hobbs and George Williams provide a comprehensive analysis of the participation of Indigenous law students in legal education, discussing some of the persisting inequities and challenges they face along the way. Catherine Greentree argues for retaining the royal prerogative of mercy in New South Wales, as she argues it can fill the aims of the criminal justice system. Lisa Young examines the inconsistencies in determining the relevance of mature minors' decision-making capacity and the impact this has on parenting disputes. Continuing this focus on children in the law, Sonia Brubaker, Natalie Hodgson, Jane Goodman-Delahunty, Martine Powell, and Nina Westerer consider the capacity of children to testify in court through a thorough analysis of trial transcripts. Max Henshaw, Lorana Bartels, and Anthony Hopkins examine the effectiveness of applying a therapeutic jurisprudence lens to parole reform to lower reoffending. And Andrew Lynch and Professor Williams, with his second appearance in tonight's issue, provide the 2018 instalment of their much-loved annual High Court Statistics on Constitutional Law. Finally, the two remaining articles have been selected as the lead articles of tonight's issue, which inform the topic of the launch event, which is Reconceptualizing Environmental Harm. Rebecca Nelson critically analyses how the two main federal environmental management regimes tend to assess environmental developments in isolation, thus failing to adequately account for harms caused by numerous environmental effects, which cumulatively add up over time. Hadil Alalosi and Mark Hamilton make the case for restorative justice conferencing, an alternate approach to criminal justice involving greater communication between stakeholders as a way to improve the enforcement of environmental crimes. These two cross-disciplinary perspectives, whilst focusing on very different material, raise similar questions of how we fundamentally characterise environmental harm and evaluate its impacts. And further, They invite us to question the effectiveness of current authorities and management systems, and instead ask us to conceptualise more appropriate methods of harm mitigation. We are very grateful to have the Honourable Justice Rachel Pepper to deliver the keynote address tonight and share her thoughts on this topic. Justice Pepper was appointed as the Judge of the Land and Environment Court of New South Wales in May 2009. Prior to this, from 1997 until her honours appointment to the bench, she practised as a barrister at the New South Wales Bar. Whilst at the bar, she was a member of the Bar Council and was secretary from 2006 to 2009. Prior to being called to the bar, she was the associate to Justice Michael McHugh in the High Court of Australia. 2015, Justice Pepper was the inaugural visiting fellow at the ANU Centre for International and Public Law. In 2017 and 18, she chaired the scientific inquiry into hydraulic fracturing of onshore unconventional gas reservoirs and associated activities in the Northern Territory. She is an adjunct professor of the University of Sydney's Law School, where she lectures in environmental litigation. She is also an ambassador for 2010. I would now like to welcome Her Honour to speak on the topic of reconceptualising environmental harm.
I would like to acknowledge and pay my respects to the traditional owners of the land upon which we meet today, the Gadigal people of the mighty Eora Nation. I would like to pay my respects to the elders, past, present, and emerging, and I extend that respect to other Indigenous Australians who are present here today. I acknowledge that this land, which we benefit from, was not given, that sovereignty was never ceded, and that it always was and always will be Aboriginal land. Now I must commend the editorial team and indeed the authors on what is a truly impressive and weighty tome, which is issue 4 of volume 32 of the University of New South Wales Law Journal. I can't say that I have read all the articles, but what I was impressed with was the diversity of the content and the range of expertise and knowledge that was on display. I truly commend this issue to you here in the room today, if you haven't read it all, and to others who I hope will grab it. I know the topic was reconceptualizing environmental harm, but again, I couldn't really do justice to the 2 environmental articles, and I was very pleased to see that there were environmental articles in the issue. So what I want to do today then is talk about basically environmental harm or environmental rights through the prism of constitutional law, or at least constitutions, and through the prism of human rights, and see whether or not there's any benefit in conceptualizing environmental rights as human rights. Now, it's not the raving of some inner city lunatic to state that what is surely, as Australia burns, obvious, that environmental harm can cause human harm, and in doing so is highly likely to adversely impact human rights. Now, such a claim is neither novel nor is it woke. The symbiotic relationship between environmental protection and human rights has been recognised internationally since at least 1972, and the Stockholm Declaration declared that a healthy environment is essential to the enjoyment of basic human rights and the right to life itself. Nevertheless, our exploitation of nature for benefit, principally financial, has continued since at least our mastery of fire, and it has become so pernicious and so pervasive that it is now an existential threat. The climate crisis of the Anthropocene age is upon us. In the 2019 report of the Intergovernmental Panel on Climate Change, or the IPCC report, describes the predicted trajectory of the environmental catastrophe that we will face over the next century. For example, under the various scenarios considered by the IPCC report, including those in which emissions are significantly reduced, by 2050, low-lying megacities and small islands are projected to experience extreme high-level sea level events annually. Historically, these occurred once every 100 years. Now, such disasters will create large groups of displaced people, destroy infrastructure, and compromise our food supply. This will directly compromise the most basic of human rights of those affected, including the right to self-determination, the right to life, the right to food and water, the right to housing and shelter, and the right to security. The PCC report also highlights the destructive impact that the warming of the oceans will have on ecosystems, threatening food security, income, livelihoods. For example, scientists predict that if current fishing practices continue, all the commercially targeted fish species will suffer population collapse by 2048. That is less than 30 years from now. Now, destruction of the natural environment will have a particularly devastating effect on those indigenous communities who rely on natural resources for subsistence and for cultural identity, preventing these groups from exercising their rights to practice and maintain their culture. The report concludes that the detrimental impacts of marine warming will cause potentially rapid and irreversible loss of culture and local knowledge and indigenous knowledge, and negative impacts on traditional diets and food security, aesthetic aspects, and marine recreational activities. Ocean ecosystem loss will undermine the ocean's role in cultural, recreational, and intrinsic values important for human identity and well-being. Now, air pollution is already undermining our human rights. In 2005, for example, the European Court of Human Rights determined in the case of Fedovaya and Russia that the applicant there had alleged that the operation of a steel plant in close proximity to her home endangered her health and well-being, in contravention of Article 8 of the European Convention on Human Rights. Now, Article 8 protects the right to private and family life. The court accepted that the levels of toxic elements in the air caused by the operation of the plant, which had considerably exceeded safe levels over a long period of time, either caused or increased the applicant's vulnerability to illness. The court found that although Article 8 is not violated every time environmental deterioration occurs, the adverse effects of the environmental pollution in this case had reached a level sufficient to bring it within the scope of Article 8. The court held that the state had a positive obligation to take steps to prevent interference with her rights. The state was ordered to pay the applicant 6,000 euros in addition to her legal costs. The case may be seen, I think, as an early illustration of the greening of human rights. Now, in light of the climate crisis that we currently face, should environmental rights be viewed through the prism of human rights? Would this give the former more force, more social acceptability, more political leverage? The rhetoric of human rights offers a pre-existing accepted framework from which to pursue environmental goals. Human rights are recognized in many treaties, constitutions, and statutes, and have a number of international, regional, and domestic institutions and frameworks in place to enforce them. A right-centered approach to environmental protection is arguably more able to be leveraged or to leverage the inherent anthropocentrism of our legal system in a manner that results in tangible, positive environmental outcomes. Put another way, environmental protection that is based on the established language of human rights is more likely to be accepted in the current political climate than arguments asserting rights possessed by nature of its own. A human rights conceptualization of environmental protection, of course, has been criticized as being too anthropocentric rather than ecocentric. This is because it posits the impact of environmental harm on humans rather than on flora and fauna as its central focal point. The concern is that such an approach fails to recognize the value and importance of natural ecosystems beyond their use or benefit to humans. It posits a reduction of nature to no more than an inanimate machine existing to serve human needs. Accordingly, in some countries, legal protections that are directed to the impact of environmental harm on humans has been redirected towards the impact of environmental harm on nature itself. For example, in Bolivia, that country's conferred legal rights and personhood to Mother Earth, who can be represented by humans in court. The Bolivian Constitution provides a right to a healthy, protected, and balanced environment and allows any person to take legal action in defense of environmental rights. Similarly, the Ecuadorian Constitution refers to Pachamama, a deified representation of nature, and confers upon it a right to integral respect for its existence and for the maintenance and regeneration of its life cycles, structures, functions, and evolutionary processes. All communities and public authorities are obliged to protect this right. In New Zealand, a national park has been declared to be a legal entity with legal rights able to be exercised on its behalf. So too in India with respect to significant rivers and natural systems. So it was in 2017, the High Court of Uttarakhand declared that the river Ganges and Yamuna were legal persons with all the corresponding rights, duties, and liabilities of a living person. The declaration was based on the court's determination that the rivers were sacred and revered to Hindus, and therefore that they were central to the existence of half the Indian population and their health and well-being. Now, the decision was, however, overturned by the Supreme Court on appeal, which held that the declaration had interfered with the rights of other provinces and other nations because the rivers extended beyond the borders of India into Bangladesh. Moreover, it was inappropriate in a secular society. The Supreme Court also accepted the state submission that the ruling gave rise to uncertain and complex legal issues because of the consequences of granting legal rights to a river were not clearly defined. Who would be responsible for providing compensation in the event of a flood? Substantive environmental obligations recognized by international law are rooted in the adoption of legal and institutional frameworks that seek to avoid environmental harm, which is an impact on human rights. In 2013, the UN report on the independent expert of the issue of human rights obligations relating to the enjoyment of a safe, clean, healthy, and sustainable environment recognized that, at the very least, international human rights law imposes procedural obligations on states in relation to environmental protection. Such procedural obligations include a duty to assess environmental impacts, to publicize information relevant to environmental decision-making, to facilitate public participation in environmental decision-making, and to provide access to justice to seek redress for harm. Well, procedural rights are essential to the enforcement of substantive environmental rights. The seminal rights instrument, the Convention for the Protection of Human Rights and Fundamental Freedoms, protects procedural environmental rights such as the right to freedom of expression, the right to freedom of assembly and association, and the right to an effective remedy. There is, in addition, the right to information, which is important because without it there can be no meaningful participation in environmental decision-making. The right to information is recognized in many environmental treaties and instruments, most notably Europe's 1998 Aarhus Convention and the Universal Declaration of Human Rights. It is so fundamental that it has been incorporated into the national law of many countries. Freestanding domestic freedom of information laws are common, and some countries, such as New Zealand and Mexico, and in those countries, they are in fact constitutionally entrenched. The right to public participation is another important procedural environmental right. It enables stakeholders to be involved in environmental decision-making by, for example, being entitled to make submissions, to ask questions, and to attend public meetings. This participation improves the quality and legitimacy of decision-making. Over 131 countries have constitutional provisions relating to the right to public participation. Now, significantly, the UN Independent Expert Report that I referred to a moment ago found that the procedural human rights obligations of states are relatively established with respect to environmental protections. But when it comes to substantive human right obligations offering environmental protection, the same cannot be said. And even in relation to procedural rights, there are issues of implementation and enforcement. So, does the domestic constitutional law of states offer a solution? That is, are rights that are either expressly or impliedly directed to the protection of the environment, which are afforded constitutional status, able to better achieve environmental outcomes? Many countries have included explicit environmental rights in their constitutions. Alternatively, such rights are implied through the construction of human rights already contained in a constitution. A third approach is to include constitutional policy directives mandating specific environmental outcomes. Now, while there remains no international treaty which contains the right to a clean and healthy environment, as of January 2019, 150 countries have constitutionally recognized environmental protections in some way. Now, domestic constitutional protection of environmental rights has distinct advantages over international protection beyond those of enforcement, because such protections are likely to be more locally adapted and therefore more readily accepted. This is important because environmental rights are often required to balance against other rights, such as economic rights. Unlike ordinary statutory regulation, constitutional protection has the benefit of longevity. Constitutions tend to, not always, endure beyond political cycles. Now, constitutional recognition of environmental rights also has a powerful normative and symbolic value. By framing environmental harm as a violation of a fundamental constitutional right, the legal legitimacy of these rights is augmented and reinforced. Again, this is important because environmental decision-making is polycentric in nature, often trying to balance competing priorities. The perceived significance of breaching a constitutionally protected environmental right will be far greater than other statutory rights. Moreover, the existence of a constitutional environmental right is a powerful incentive to develop sound domestic environmental policy. Nationally entrenched environmental rights are also a necessary adjunct to international law, given the principle of customary law that states that permanent sovereignty over natural resources within their that states have permanent sovereignty over natural resources within their territory. This significantly limits the extent to which international law can provide environmental redress to individuals against a state. Now, notwithstanding the lacuna in the Australian Constitution, the existence of express constitutional environmental rights is increasingly common. In fact, almost every constitution adopted or revised since 1970 either states the principle that an environment of a specified quality constitutes a human right or imposes environmental duties on the state. The Constitution of the Ukraine enshrines a right to an environment that is safe for life and health. Hungary, Turkey, Indonesia, and Nicaragua entrench a right to a healthy environment, while South Africa specifies an environment that is not harmful to health or well-being. South Korea uses the descriptor of pleasant, and the Philippines guarantees a balanced and healthful ecology in accord with the rhythm and harmony of nature. In Chile, the right is to an environment free from contamination, and some constitutions, such as those of Kenya, Bolivia, South Sudan, and South Africa, explicitly extends substantive rights to future generations. Other constitutional rights are prescriptive. In Bhutan and Kenya, for example, the government is obliged to maintain a specified percentage of tree cover across the country. And in some countries, constitutional environmental rights have been construed as including a duty to ensure that natural resources are responsibly managed. The sustainable use of resources is formulated as a duty of the state in constitutions of Bolivia, the Dominican Republic, and Eritrea. Let me give you an illustration. Now, Section 16, as I referred to, of Article 2 of the Constitution of the Republic of the Philippines, drafted in 1987, provides that the state shall protect and advance the right of the people to a balanced and healthful ecology in accord with the rhythm and harmony of nature. Now, in a celebrated case called Miners Oposa and Factoran, the Supreme Court of the Philippines applied Article 2, Section 16 of Article 2, to recognize the right of one generation, who were miners, to bring a class action on behalf of generations yet unborn, invoking the principle of intergenerational equity, to ensure the protection of that right to a sound environment for generations to come. In granting the petition for writ of certiorari, the court described the right to a balanced and healthful ecology afforded by Article 2 as a fundamental legal right, and that such rights belong to a different category of rights altogether, for it concerns nothing less than the self-preservation and self-perpetuation, the advancement of which may even be said to predate all governments and constitutions. As a matter of fact, these basic rights need not even be written in the Constitution, for they are assumed to exist from the inception of humankind. In 2018, the Colombian Supreme Court ordered government action to address environmental degradation. In addition to providing rights to life and to dignity, the Colombian Constitution provides that every individual has the right to enjoy a healthy environment. 25 plaintiffs filed a complaint in the court against the Colombian government, Colombian municipalities, and various corporations, alleging that climate change, in combination with the government's failure to ensure compliance with a target of net zero deforestation in the Colombian Amazon by 2020, as was agreed under the Paris Agreement, threaten their fundamental rights and the rights of future generations. The court upheld the complaint, stating that the increasing deterioration of the environment is a serious attack on current and future life and on other fundamental rights. It ordered the federal government to formulate a plan to mitigate the rate of deforestation in the Amazon, to adopt measures aimed at reducing greenhouse gas emissions, and to implement climate change adaptation strategies at all levels of government. In 2012, in the Kenyan Environment and Land Court, plaintiffs relied on their constitutional right to a clean and healthy environment. From 2006, a series of agreements had been entered into by the Kenyan government to purchase hydroelectricity from Ethiopia. Of concern was whether the development of dams in Ethiopia would reduce water flow into Lake Turkana in Kenya, a lake that supported several indigenous communities and was also a World Heritage Site. Now, the Lake Turkana Community Trust sued the Kenyan government seeking information about the purchase agreements. The court held that the government had an obligation to the communities to ensure that the resources of the lake are sustainably managed, utilized, and conserved, as well as a duty to take precautions to prevent environmental harm. The court ordered that the government disclose all information relevant to the agreements and to take all steps necessary to ensure that they fulfilled the identified constitutional obligation of responsible resource management. And as early as 2004, citizens sued the national and provincial governments and the city of Buenos Aires and 44 industrial facilities in relation to pollution of a particular river. In a series of decisions relying on Article 41 of the Constitution, the Supreme Court of Argentina ordered the government to conduct an environmental assessment and to create and implement an educational program about wastewater, to establish a comprehensive restoration and remediation plan, and ordered specific action including scheduled inspections, the closure and cleanup of illegal dumps, and the improvement of sewage treatment and stormwater discharge systems. And all of this was to be supervised by ongoing oversight by the Argentinian Federal Court of First Instance. So it was quite detailed and quite prescriptive. Now, there are regrettably few national constitutions which explicitly address climate change, but there is one. The Constitution of the Dominican Republic is the exception, and it provides for a plan of territorial ordering that assures the efficient and sustainable use of the natural resources of the nation in accordance with the need of adaptation to climate change. Now, a number of factors have been identified that make a country more or less likely to have environmental rights enshrined in their constitutions. First, they are typically contained in constitutions which have been created post-1970, which correlates roughly with the era when environmental issues became more prominent and globally recognized. Second, these countries tend to be less developed nations, which are far more likely to rely on the exploitation of natural resources and the development of primary industries for economic improvement. These countries tend to have newer constitutions, many having gained independence since the 1970s or have suffered political instability, leading to the adoption of new constitutions or significant amendments to their existing constitutions. And these constitutions, therefore, tend to be more comprehensive in relation to human rights and environmental rights. And, of course, third and conversely, countries with stable political systems are less likely to have environmental protections included in their constitutions. Now, in countries with constitutionally enshrined human rights, but no express environmental rights, superior courts have sometimes interpreted these human rights to include environmental rights. For example, the right to life, the right to health, the right to food and water, the right to dignity. As in 1995, proceedings were commenced in the Supreme Court of Nepal by citizens and non-government organizations challenging the operation of a marble factory in the Godavari forest on the basis that it had caused environmental degradation to the forest and the surrounding environment. The court held that the constitutional protection of the right to life included the right to a clean and healthy environment. The court therefore issued a directive to the Parliament to pass legislation to protect the forest, including its air, its water, and its people. And similarly, courts in India and Pakistan have construed the constitutional right to life to include a right to a healthy environment. Likewise, courts in Costa Rica and Bangladesh have held that a right to a healthy environment is necessary to ensure that the right to life is fully enjoyed. By contrast, courts in the United States have rejected the argument that constitutional rights to life or liberty provide an implied right to a clean environment. And lastly, some constitutions contain policy directives mandating positive environmental outcomes. For example, Article 33 of the Constitution of Qatar provides that the state endeavors to protect the environment and its natural balance to achieve comprehensive and sustainable development for all generations. But aside from their vague and usually indeterminate content, these provisions are generally unenforceable. Courts in the Netherlands and Greece have therefore refused to recognize actionable substantive environmental rights from constitutional directives requiring environmental policy. Nevertheless, these constitutional policy directives can assist in establishing environmental norms that can meaningfully influence the development of improved environmental policy and the creation of tangible enforceable rights. For example, in India, Article 48A of the Constitution provides that the state shall endeavour to protect and improve the environment and to safeguard the forests and wildlife of the country. This provision is drafted as a directive principle of state policy, which shall not be enforceable by any court. Nevertheless, the Supreme Court of India has held that environmental protection is a necessary element of rights that do enjoy constitutional protection and is therefore enforceable. Now, the willing of that court, I should add, to expand the scope of constitutional protection has not gone without criticism, with some commentators arguing that this has led to an institutional imbalance whereby the judiciary is relied upon to remedy the failure of the government to develop and implement policy. The court was accused of usurping its role in of the legislature and of exercising legislative authority upon its decision in Union of India, where a new national forest policy was established in conformity with a constitutional principle. Now, I want to turn to the efficacy of constitutional environmental protections. Now, there's been an increase in the quantity of environmental laws in the last 5 decades. The UN Environment Programme has found that with respect to their efficacy, however, government implementation and enforcement is irregular, incomplete, and ineffective. Constitutional environmental rights alone are insufficient to achieve sound environmental outcomes. Good policy, political will, adequate resourcing, and the development of supporting institutional frameworks is also required. Countries that have strong constitutional environmental rights do not necessarily enjoy strong environmental protection. For example, India was ranked 177th out of 180 countries on the Yale Center for Environmental Law Policy's 2018 Environmental Performance Index. Bangladesh and Nepal were ranked 179 and 176, respectively. Conversely, countries such as the United Kingdom and Iceland, which have no constitutionally entrenched environmental rights, have been recognized as having reasonably good environmental records, ranking 6th and 11th, respectively, out of 180 countries in 2018. Nevertheless, research has demonstrated that constitutional environmental rights can lead to beneficial environmental outcomes, especially in relation to the enactment of legislation directed at protecting the environment. A 2012 study found that 78 out of 92 countries which provide for a constitutional right to live in a healthy environment enacted domestic legislation to give effect to this right. Based on 2008 data, the study found that 116 countries with constitutional environmental rights had a materially smaller ecological footprint than 34 countries with no such rights. Similarly, a 2016 study found that the presence of constitutional environmental rights led to better scores on the Environmental Performance Index. Now, the authors of that study suggest that constitutional environmental protection creates policy incentives to enact laws that targeted at specific environmental issues and problems. For example, Argentina's constitution provides a right to a balanced, healthful environment, which has encouraged the promulgation of a plethora of environmental laws in that country, certainly of recent times. Now, of course, the proper drafting of constitutional environmental rights is important to maximize their beneficial operation. If the rights are ambiguous, or their content is vague or uncertain, or if they are not sufficiently adapted to local conditions, enforcement is likely to be more difficult. The greater the equivocation, the greater the need for court intervention, and courts are understandably cautious in enforcing vague environmental rights, especially those that are constitutionally entrenched, either explicitly or by implication. Thus, the Supreme Court of Nepal held that it was inappropriate to issue a writ of mandamus requiring a defendant to comply with a constitutional duty giving effect to the right to life when it could not be inferred from that duty that it encompassed environmental degradation. Further, absent appropriate enforcement mechanisms, the policy incentives created by constitutional rights will be undermined. Critically, what is required, for example, is access to that right by way of liberal standing provisions to enforce it. Without broad or open standing to enforce rights, constitutional protection becomes arbitrary and discretionary and not obligatory. In countries with restrictive standing laws, such as the United States, access to justice is often limited to individuals who are personally and directly affected by the contravention of an environmental right. However, as the article by Dr. Al-Alosi and Mr. Hamilton notes, environmental harm often only indirectly affects communities and populations by reason of the harm to the environment itself. Now, many constitutions are silent on how environmental rights are enforced. 22 out of 140 nations state how the constitutional environmental rights enshrined in their constitutions are to be enforced, including whether citizens can enforce them currily. Such uncertainty is apt to discourage vindication of such rights through litigation. Even where liberal standing rules exist and enforcement mechanisms are clear, actions may still not be commenced and the court orders may still be ignored. Relevant government departments are often under-resourced and lacking in accountability, particularly in developing countries. Without a culture of compliance and transparency and the political will to prioritize and implement environmental protections, even the most robust environmental rights may ultimately prove Pyrrhic. Many constitutional environmental rights lie dormant by reason of economic, political, and financial inertia. For example, South Africa's constitution guarantees a right to a clean environment and provides for open standing and access to the constitutional courts of that country, but that court has yet to enforce that right. And notwithstanding that Brazil's strongly stated environmental rights, notwithstanding that Brazil has strongly expressed and stated environmental rights, environmental protection is very much secondary to economic demands in that country. And finally, environmental rights may not be enforced because the resources needed to do so are simply not available. The cost of vindicating environmental rights is often high. Extensive remediation by multiple entities, both public and private, may be required. Court supervision of such remediation may be necessary. Again, South Africa's constitution includes a right to water and a requirement that the state take reasonable legislative and other measures within its available resources to achieve the progressive realization of these rights. In Mazibuko and City of Johannesburg, the Constitutional Court held that the measure of the state's compliance with the requirement to achieve progressive realization of constitutional rights was to be assessed not by its success, but on the reasonableness of its efforts. And it may be for this reason that in 2014, the South African Human Rights Commission reported that 11% of households do not have any sanitation, despite that right seemingly being constitutionally protected. Now, I now want to turn to environmental rights within the Australian constitutional framework. Now, turning first to look at the federal situation. There are no environmental rights either explicitly or implicitly protected under the Commonwealth Constitution. In fact, there are very few positive, that is the right to something, express rights provided for in the Commonwealth Constitution. There's a right to acquisition on property on just terms or a right to trial by jury for indictable Commonwealth offences, but they are few and far between. Now, Section 100 of the Constitution refers to the reasonable use of waters of rivers for conservation or irrigation. But this neither imposes a duty on the Commonwealth to protect these waters, nor does it confer any rights enforceable by individuals. Now, the right to water as a fundamental human right has not been recognised in the Constitution or indeed in any federal or state legislation. And few rights have been implied into the Constitution. For example, the right of the freedom of political communication. Professor George Williams has optimistically suggested that there is the potential for further rights to be implied in the Constitution. He argues that structures and doctrines inherent in the Constitution, federalism, representative and responsible government, and the separation of powers, can provide a foundation for the protection of rights, even when those rights are not apparent on the face of any given provision. But even assuming that further rights were to be implied into the Constitution, which in my view is doubtful, implied rights are limited in significant ways. They are likely to be restricted to negative rights, that is, the right affording protection from an exercise of governmental power. And they are unlikely to offer any protection from environmental harm caused by the acts of private individuals. Finally, the creation of new rights by amendment is not easy. Only 18% of all proposed amendments to the Constitution have been successful. Now, given these limitations, the scope for constitutional environmental protection in Australia at a Commonwealth level is extremely limited. Well, what about the states? The state constitutions are similarly bereft. States may amend their constitutions by ordinary legislation, but such amendment is rare. And what state parliament giveth, state parliament can taketh away. Some provisions may be entrenched by manner and form requirements, but the state's power to do this is usually quite limited. Now, Victoria, Queensland, and the ACT have introduced statutory bills of rights. The ACT has enacted the Human Rights Act in 2004, Victoria has the Charter of Human Rights and Responsibilities 2006, and Queensland has recently passed the Human Rights Act 2019, which will commence on the 1st of January 2020. Now, all three enactments provide for a right to life, a right to take part in public life, the right to peaceful assembly and association, and for the protection of families and children. Well, these are rights which could arguably be interpreted to include environmental rights, as has occurred overseas. But I think that would be perhaps a brave judicial officer who went down that path. Now, the rights in these, included in these three enactments do, however, include procedural rights necessary in the promotion and enforcement of substantive environmental rights, such as the right to take part in public life and the right to assembly and association. In addition, all three statutes provide for the protection of cultural rights, which specifically refer to the right of Aboriginal people to maintain their spiritual, material, and economic relationships with the land. An approval granted to an extractive industry where the operation of that industry impinges upon an Indigenous person's spiritual relationship with the subject land might be, indeed, incompatible with that right. Now, the Acts contain a directive that all statutory provisions must, so far as possible, be construed in a way that is compatible with human rights. But the efficacy of such a directive after Monsivillage and the Queen is doubtful. In my view, substantively, these acts afford little by way of enforceable standalone rights. Generally, proposed legislation must be accompanied by a statement of compatibility concerning whether or not the bill is compatible with the human rights contained within the state's respective human rights legislation, which must be considered prior to the proposed legislation being passed. But a failure to comply with the requirement to provide a statement of compatibility has no consequence for the validity of the law. Moreover, in Queensland and Victoria, there's a provision for the Parliament to make an override declaration in respect of legislation that has effect, despite any incompatibility with a statutory human right. And while in all three states, the relevant Supreme Court may make a declaration of incompatibility to the effect that a provision cannot be interpreted in a way that is consistent with human rights, again, this declaration has no impact on the validity of the law. Where such a declaration is made, the minister administering the relevant act must prepare a written response and table it before Parliament within 6 months. There have only been 2 declarations made, one under the ACT Human Rights Act and one under the Victorian Charter. Now, in Victoria, Section 38 imposes 2 obligations on public authorities. First, a public authority must not act incompatibly with human rights, and second, a public authority must not fail to give proper consideration to a relevant human right when making a decision or taking an action. Now, where breach of Section 38 occurs, Section 39 permits legal proceedings to be brought by a person affected, but only in circumstances where that person is able, independent of the Charter, to seek relief, excluding damages, in respect of the impugned decision or act. The Victorian Charter therefore extends the available grounds of review in judicial review proceedings to include unlawfulness arising by reason of breach of Section 38 of the Charter, but this cannot be the sole basis of the claim. Nevertheless, despite their limitations, reviews of the ACT Human Rights Act and the Victorian Charter suggest that they have had a significant impact in the policy arena already, improving decision-making and raising the awareness of human rights within government bodies. Given that environmental rights are increasingly being perceived as an aspect of basic human rights, such as the right to life, the necessity to protect the environment could perhaps fall for consideration under these acts, sooner rather than later, or indeed at all. To conclude, environmental rights are increasingly being conceived, overseas at least, as an aspect of human rights, with many states affording environmental rights, either directly or indirectly, constitutional protection. Research has demonstrated a material connection between constitutionally enshrined environmental rights and improved environmental outcomes at the domestic level. In the absence of an ability to entrench constitutional environmental rights in Australia, there may be some scope for state bills of rights to implicitly provide a, albeit limited, measure of environmental protection. As our climate emergency escalates, that is, as the water gets hotter and the burden on the camel's back grows ever heavier, and in this regard I would commend the article by Dr. Rebecca Nelson in the issue, having an ever more deleterious and direct and immediate impact on the very environment that we all depend upon for the full enjoyment of our human rights, breathable air, potable water, and the ability to feed and shelter ourselves, the necessity to afford meaningful and enduring protection to the environment becomes ever more pressing. If we lack the collective will to protect the environment for its own sake, then we must conceive environmental rights as an essential aspect of human rights. I started with a quote from a conservative politician, and I want to end with a quote from a conservative politician. As was observed 3 decades ago, what we are now doing to the world by degrading the land surfaces, by polluting the waters, and by adding greenhouse gases to the air at an unprecedented rate, all of this is new in the existence of the Earth. Whole areas of our planet could be subject to drought and starvation if the pattern of rains and monsoons were to change as a result of the destruction of forests and the accumulation of greenhouse gases. The evidence is there. The damage is being done. The environmental challenge which confronts the whole world demands an equivalent response from the whole world. Every country will be affected, and no one can opt out. Now, that was Margaret Thatcher in 1989 addressing the United Nations. Hardly an inner-city greenie. Thank you.
Well, thank you very much. My name is George Williams. I'm the Dean of Law here, and my job is to give a brief vote of thanks. I'd like firstly to thank the firm, King & Wood Mallesons. It's a very close partner of ours, and thank you to Michael in particular for coming to help us launch this journal tonight. King & Wood Mallesons is distinguished by the fact that it has so many of our most talented alumni, if nothing else. We also thank the firm enormously for the provision of facilities tonight and the fact that our partnership extends across our Youth Law Centre, through to our chair in FinTech, through to many other areas. It's a really deep and enduring partnership which we value enormously. I'd also like to congratulate the many people in the room who've been involved in this issue tonight. I know just how much blood, sweat and yes, tears has gone into this issue, that every word has been poured over, and I know that it comes off a really high base. So we're really proud at the faculty with the quality of the issue that is put out every year by this journal. And we know that as a world-leading law school, this journal is a real ambassador for us when it comes to the very best scholarship around the world. And I think the best I can say about the quality of this journal, particularly given the many editors and others in the room tonight from previous issues, that this is a very worthy successor. This lives up to the standards that we expect at the university, the standards that have been set over many years. And it's a really fine issue. And I know there's a lot of obsession, a lot of very close analysis that goes into these issues, and the quality is really borne out with what we see tonight. And finally, I'd like to say thanks in particular to our special guest, Justice Pepper. We could not have asked for a more broad-ranging discussion of these issues, and I must admit, as a constitutional lawyer, I learnt an enormous amount tonight from that discussion. I was not familiar with just how deep and far-reaching many of these provisions are in constitutions ranging from Bolivia through to South Korea, through to Indonesia, indeed throughout the world. And I think her talk really reminds us of the really powerful effect that law can have. When it's well drafted, the fact that constitutions can play a determinative role in protecting the environment. And I certainly found it a really wide-ranging, thoughtful and really persuasive address about the challenge we face and the role I think that we as lawyers can play in seeking to make a more positive impact on the environment. So thank you, Justice Pepper, and thank you again to the journal editors.
Thank you, George. That brings the formal component of the evening to a close. Feel free to grab a copy of the journal if you haven't already, and stick around for canapes and drinks. Thank you.